You might remember this video here that I did in September last year as a pro bono case. Well, it's still going on. Now, I take no pleasure in criticizing the police, but in this case, it's absolutely justified. So allow me to explain to you what happened. So obviously, in that case, if you don't remember, the police doorstepped a house to seize the phone of a young girl. As it happens, long story short, it ended up with no further action because there wasn't evidence that she was involved in what they said she was. But the police, in the meantime, did a public announcement about it, which I felt was too much. We complained about that. But in the process of my pro bono assistance here, we also requested the body-worn video footage borne by these officers in this incident so that we could look at it and consider our position and so on. Obviously, I can't go into too much detail about the rest of the case, but I can talk to you about certain bits of it, which is what I'm doing here. And it is very much in the public interest to do so. But there's a very important point about this interaction here, which I'm going to show you in just a moment, which makes it all the more relevant what I'm going to talk to you about in this particular video. So first of all, if you do appreciate my input in these videos and fighting for people's rights here, as I will continue to do so, please do subscribe to the channel. That does help the channel grow. I am still trying to hit that 1 million subscriber mark. It's taken me years so far. I will keep plugging away at it. So thank you for doing that. I really do appreciate it. So there's one bit of this video here by these officers and what they said that makes this absolutely relevant to what I'm going to say in this video. Allow me to just show you what the officer says here. You'll remember it when you see it, and this is why it's so important to hold the police to account. Listen to this, 5 seconds worth.
Okay, what was it?
Sorry, I don't like the camera. You can have my body cam. I can exhibit that to you. I just don't.
And so as I take a breath in the video that I'm talking about here, I jump in to talk about that point there because the officer here says she doesn't like the camera, but she says, you can have my body-worn camera. I will exhibit that to you. Now, obviously, she was right. My client here taking this video was right to keep filming so that she had a contemporaneous record of what happened, because otherwise she just wasn't going to get that from the police. And despite numerous requests, formal requests, including by me back in September, they still haven't provided it. But it gets worse than that. In fact, we made a number of requests for a number of bits of information, many of which the police simply haven't provided. But I'll come to the worst one, which is about this video footage in a minute or so. But let me talk about a couple of other bits first, because again, this is why this isn't just about this case anymore. This is about every interaction you have with the police, everything that happens, and contemporaneous records, contemporaneous notes. That just means at the same time or around about the same time that it happened, which makes it the most reliable, the most trustworthy, the most relevant document and records of what happened if it goes to a court later on. So it is absolutely important that you get these records. That's why I always say, make a note of the conversation, follow it up with an email. At the very, very least, make a written note of what happened, date it, sign it. And then if ever you get to court later, you can say, well, here's my note of what happened. And therefore, you know, it's more believable. And yes, on the one hand, some people can make things up, but the court is usually very good at deciphering what's been made up and all of this sort of stuff. So the court will filter that out if necessary. But generally speaking, a contemporaneous note and a record of what happened is the best thing to rely upon. And in this case here, as I've said many times before, video evidence of what happened is usually the best kind of evidence. You can normally see exactly what happened. And we've seen that with the Manchester airport case where the footage was leaked to show exactly what happened there. And, you know, maybe if that footage wasn't leaked and released, maybe the case would have taken a different turn. Who knows, really? But we use the same argument here, so I'll come back to that in a moment. In other rather fantastic news, you may have heard that our government has stepped back from the idea of banning VPNs. But not only that, they've also been upheld by the Court of Justice of the European Union in a landmark case which was all about the online publication of Anne Frank's historical manuscripts. At the core, it asked the top judges in Europe a highly technical legal question. If a publisher actively tries to block visitors from a specific country, are they still breaking the law if the user gets around those restrictions using a VPN? The court said no. As long as the website uses state-of-the-art geo-blocking technology, the publisher cannot be held liable for copyright infringement just because a reader uses a VPN to access that content. And so, again, giving freedom to the use of VPNs. This is not about encouraging anyone to break the law. It is just that publishers should not be held liable just because someone uses a VPN, which of course gives you a virtual location based on using the VPN software. But more than that, in my view, I believe the government has recognized that software such as NordVPN, who sponsors my channel here, is more than just a VPN, very much more. It is now an all-in-one security powerhouse, which gives you security online, monitoring and scanning websites and downloads before they get on your system. You see, most antivirus software will wait until a file is on your system and then scan it and then alert you to the fact. But NordVPN proactively warns you about these malicious software downloads and websites that you might visit, as well as all sorts of other security features built into the software. And as the sponsor to my channel here, you will get 4 months additional free off the 2-year plan using my code BBB, which I'll put on screen and in the description below. It will give you security and peace of mind whilst you download the software on all your devices, wherever you're traveling. So use my code BBB and that'll give you 4 months free. But the police in this case were also asked to provide the police pocket notebooks. Now, without commenting too much on this specific case, you understand, for obvious professional reasons, I will speak generally and say that police pocket notebooks are an official contemporaneous record of what the police did, where they went, who they spoke to, how they acted, and what was the response and what were the concerns and all of this sort of stuff. It is a record of what the police did. It's the best sort of contemporaneous record, both for the court record as to what happened and to memory refresh for the police officers in court as to what happened. Police officers in court, for example, are routinely permitted access to their pocket notebooks as the memory refresh because they go to so many incidents that are very similar. But in relation to police pocket notebooks, the police said as follows, and I have permission to share this with you because it's of national public interest and importance, because it applies to everybody if this is the way the police respond to a request for pocket notebooks. It reads as follows. In relation to police pocket notebooks, these are not part of a structured filing system. I'll come back to that in a minute. An applicant would need to identify which officers made a pocket notebook entry for which the applicant would have been asked to sign. If there is any other relevant information which the personal data of the applicant held in a pocket notebook, it would be transferred to or copied to the relevant investigation report and be subject to the Criminal Procedure and Investigation Act. In other words, they are refusing to provide the pocket notebooks. So let's tear this apart in a little bit of detail. Let's look first of all at the right of access to police data under Part 3 of the Data Protection Act 2018. Now, the police processing of personal data for the prevention, investigation and detection or prosecution of criminal offences falls within the scope of Part 3 of the Data Protection Act 2018. This regulates the processing by law enforcement organisations for such purposes. Obviously, that includes the police. Part 3 applies to competent authorities, which is, for example, a police force. So police forces are listed in Schedule 7 to the Data Protection Act, and individuals whose personal data, that is any data that could identify an identifiable individual, has been processed for law enforcement purposes, have a right of access to that information about the processing under Chapter 3 of Part 3 of the DPA. Now, this includes the right to obtain information from the police that they are processing personal data and the right to obtain a copy of that data. Personal data held in police pocket notebooks and body-worn video footage, which I'll come to later, would constitute personal data relating to an identified or an identifiable individual, which is obviously the case where the pocket notebook or the body-worn video footage refers to or captures the person in question. But there's even more than that, because the Data Use and Access Act of 2025 amended the right of access for law enforcement processing, and Section 78(3) of that Act added a new section, subsection 2A, to Section 45 of the DPA 2018. This came into force in June 2025, but it's treated as having come into force the year before. So this amendment now requires the police to perform only a reasonable and proportionate search for personal data and information in response to a subject access request. So a reasonable and proportionate search. So if they know which officer attended when, what day, and with whom they dealt with, that should be relatively easy to find. And bearing in mind, in this particular case here, I obviously requested that information way back in September. That was 10 months ago. Bearing in mind also that they have a statutory time frame of 1 calendar month within which to respond with the data. Among many other things requested was also the names of the officers involved. And in response to that, the police said as follows: even though an officer is acting in a professional capacity, it is still their own personal information. We have not provided this information to you as part of your subject access request, as a West Midlands police officer or staff member still has the same rights to have their privacy protected under data protection laws. But respectfully, I disagree with that, because if, let's say, there was a note written for a PCX visited the premises of Mr. Y, so that sentence intrinsically links the officer's name with the individual's name. If the individual is making a request to the police force for full disclosure of the data held about them, that necessarily includes that police officer's name. Not to mention that there is an underlying cause to obtain that data in the event that there might be prospective civil claims against the police force. In other words, that would be disclosable in any event. Because if you want to bring a civil claim, that is yet another reason under GDPR for the force to be required to disclose that data, because it is contemplation of civil proceedings or any kind of legal proceedings. So if one were to make a request for the officers' names who visited a premises and there's an allegation that they entered unlawfully, seized property unlawfully, perhaps, and so on, then the names are intrinsically linked, they are personal data, and they are disclosable in any event. So I don't agree with the reasoning on that part at all. But then, and finally, we come to the body-worn video footage. And this is the bit that makes this of such important national interest that I simply had to talk to you about it. So this was obviously one of the most important things requested, the body-worn video footage, bearing in mind what the officer said at the beginning, in that she didn't like the camera, but she said, I can't exhibit this footage to you. However, the police responded as follows: you are entitled to any body-worn video footage that you appear in. However, we've conducted a search for any body-worn video footage or photos of the incident. However, there are no records on our systems. This could be due to retention and destruction policies currently in force and the records being out of the retention period, so may have been destroyed. So let's talk about that, because that is not as simple as, well, we've lost it, it's deleted, it's gone. It's not that simple. And so speaking generally about body-worn video camera footage, the deletion of body-worn camera footage raises two very distinct but very important legal issues. Firstly, whether the deletion breaches data retention obligations, because they should retain it once there's been a request made, and once there's an incident, obviously, that might pertain to legal proceedings. And secondly, whether it constitutes a criminal offence under the Data Protection Act. So under the data protection principles under Part 3 that applies to police forces under the DPA, firstly, personal data must be kept no longer than necessary for law enforcement purposes for which it's processed, and appropriate time limits must be established for periodic review, etc., for the need for continued storage. And taking everything into account, that might be a few days, it may be longer. If the data is stored longer, particularly beyond 72 hours, then the greater emphasis on the purpose of the surveillance and the necessity of the storage must be considered. So if it's an ongoing important case, obviously they keep it for the length of time. However, it is an offence under section 173 sub 3 of the DPA for a person employed by the police to alter or erase information with the intention of preventing disclosure in response to a data subject access request. Now, I'm not saying that's what's happened here, but that is what the law says. There is a defence if the alteration or erasure would have occurred even if no data subject access request would have been made. But that would be for them to argue. Deleting data to defeat a data subject access request would also breach the data protection principles, particularly for the requirement for lawful and fair processing, and the ICO would be likely to take enforcement action. So in the event, speaking generally you understand, where footage has been deleted, police should be able to retain all internal documents showing all steps taken to locate the relevant personal data as and when the subject access request was made. The key question for the police will be whether the deletion occurred as part of normal retention practices or was done in response to a subject access request. So if, speaking very generally, you understand, and being uncharitable, if the police thought that what was on the footage was problematic for them and they deleted it so as no one would see it, that would be, to say the least, seriously problematic for the police force. As to the police refusal to provide or disclose anything else, aside from the civil aspect, the police can rely on certain exemptions, which is usually ongoing investigation, ongoing offences, or linked offences, or prejudicing something else. But one of those must apply genuinely. The police cannot just rely on it as a blanket refusal. As to enforcement and remedies, there are generally two routes to enforcement and remedies here. Firstly would be the ICO, who has enforcement powers in relation to failures to comply with data subject access requests, and they can issue enforcement notices and so on and so forth. And secondly would be a judicial remedy through the courts, where a data subject could make a claim against those who they say have failed to comply with their rights under Part 3 of the DPA and seek compliance and compensation where necessary, and that could be made in both the county court and the high court. So all of these should be borne in mind by anybody who's been refused access to their data by a police force in response to your request. I hope that was interesting. It's a bit disappointing that the police say they've deleted this footage in this case, but here we are. That is where we are. As I said, this case would be ongoing, and it is still ongoing, so that's why I can only say so much about it. Most of what I say here is general for that reason. But I hope you found that interesting. Please do subscribe, and I'll see you in the next one.